So we've completed a discussion about the basics of agency law and the relationship of an agency to the principle and the consequences of forming that relationship. Now we're going to talk about two distinct concepts, the independent contractor relationship and then the employer-employee relationship, sometimes known as the master-servant relationship, and how you go about defining the differences between both of those, and then what are the consequences, what are the ramifications of being classified as one versus the other. And then we'll complete this chapter by getting into an introduction of the at-will employment doctrine that deals with when you can be fired from a job and when you're entitled to walk out of a job. And then also we'll see here that the agency relationship we discussed, there's overlap between that concept or that relationship and potentially independent contractors and also employees. An employee could be an agent for certain purposes and also be just a mere employee without any real agency power. Okay, so the independent contractor. The independent contractor is called an independent contractor because they are from the person who's hiring them to do work or contracting with them to do work. They are treated as completely independent from that person. So this is unlike an employee who works for you and comes to work every day and answers to you, and an employer who directs and may even micromanage the way that you work. The independent contractor is hired to do something, and then they're just left to go do it. And they do it in their way, whatever it takes, and however they want to do it to complete the finished product. That's entirely up to them. So whoever's helping them, let's say it's a contractor that you hire to build a house. You don't go to the job site. Some people might, but generally, you're not going to go to the job site and tell people what to do. You control people's lunch breaks. You're not going to critique how fast somebody is hammering a nail. But the independent contractor, whoever runs that enterprise, they're completely in charge of that. And this is very important, the distinction between the employment relationship and the independent contractor relationship, because it has very important consequences. Most importantly, you as someone who contracts with an independent contractor to do a job, you're not liable for things that they screw up on the job site. So if somebody gets injured, for instance, because of their negligence on the job site, that's really none of your business, right? That's the independent contractor, whoever. Your business is just to get the completed project. If it's a house, you just have to. Your responsibility is simply to pay for that completed project. At the end of it, or in whatever increments you contract to do. But other than that, it's their business is all their business, and it has nothing to do with you. Unlike an employer, which you'll see, it has what we call vicarious liability, where you are responsible for things that other people screw up, even though it wasn't your actual fault as the owner, because of the relationship between the employer and the employee. Now, there's other consequences to this. So again, a good thing is that you're not liable for things that go wrong. I mentioned like a tort where somebody gets injured, but also contracts that they enter into. You're just responsible for that one contract. If they have to enter into relationships with other people, if they have to subcontract some of the work out, those contracts aren't any of your business. That's their business. And so in that way, they don't usually act as an agent. There are some situations where they might act as your agent for certain purposes, but generally not. Now, employers have other responsibilities that towards employees, or when they have employees, that you don't have with an independent contractor. So employers, for one thing, in each state, if you have a sufficient number of employees, you're going to have to pay for workers' comp insurance or pay into the unemployment fund. You also have to deduct taxes from the money that you pay those employees. You deduct some called Fica taxes, which include Social Security and Medicare, some of them from the employer's paycheck, but you're also responsible to pay what you take from the paycheck is actually only half of what's owed the government. The other half has to be paid separately by the employer. So whatever you're paying them in salary, it actually costs more because you've got additional taxes that have to be paid and reported quarterly for those Social Security and Medicare taxes. So in other words, there's some extra cost and extra work and paperwork that has to be done and responsibility when it comes to when you have an employee. With an independent contractor, though, if you treat them as an independent contractor, I don't have to do any of that for you. I'm not responsible for your employees as the contractor, their workers' comp. I don't have to worry about their unemployment insurance payments or managing their Fica taxes and taking that out for them and paying my share. I just have to pay you what is owed on the contract. So it's just one payment for the whole work, and I don't have to worry about that. Now that is a lot of responsibility that you escape when somebody that you're working with is labeled as an independent contractor. And for this reason, a lot of people who actually have an employee, especially like a small business where they have like maybe one person working for them or just a couple, they'll have an agreement they may have in writing that says, we agree that we're just independent contractors. But that is not actually what determines the classification. You can call yourselves whatever you want. The key to determining who is an employee and who's an independent contractor comes down to the actions and the way that you treat them. So if you have somebody working for you that you call an independent contractor, if you're actually treating them as an employee, you could find out years down the road that you now owe some back taxes because you were supposed to be, if you were treating them as an employee, you should have been accounting for those taxes, and if you have enough employees, maybe workers' comp that you weren't paying into or unemployment insurance. And then also, of course, if they injure somebody in their work, you may find yourself surprisingly vicariously liable for that. Even though you call them an independent contractor, if you weren't treating them that way, then you could still be vicariously liable, even though you had an express agreement to the contrary. So this gets to how you create an independent contractor versus an employment relationship. And again, like with most other areas of the law, if the law says you are something based on a set of circumstances, it doesn't matter that you say otherwise. A court will rewrite your agreement in the way that to reflect the actual situation. Like with partners, we saw in that case where we had two people investing in a business. They never behaved as co-owners to carry on a profit with two or more people. They were behaving as investors. And so even though they may have even called themselves partners at some point, the law is just going to determine that you are what you are based on the relationship. So it's something to keep in mind. Even if you contract with somebody and say, we both agree that we're independent contractors, you have to make sure you treat them as independent contractors. And I alluded a little bit to that, what goes into that in terms of controlling people on the job site, but we'll talk specifically about what makes that happen when we talk about the employment relationship. This is a slide that shows you how these concepts can overlap with the agency doctrine. You can have an employee who isn't really an agent for you at all because they have no authority to enter into contracts on your behalf. And you can have kind of any number of these situations. This just kind of shows you an example of some examples of how those concepts can interact. This is just a simple case that it talks about a guy who's injured doing roofing work, and he tries to sue the company. The place that he works for, he feels, put him in a dangerous situation when doing this roofing work, exposing him to, quote, an inherently dangerous job. So he tries to sue the company that hired his company to do the work, and he loses the case because they're not responsible. It's just your employer who's responsible, not anybody else who might hire your boss to do work for them. All right, the employment relationship. I said that this is sometimes called the master-servant relationship. It's kind of an old term, but the reason it's called that sometimes is because that is what the difference between an independent contractor and an employee is. When you're an employee, you know this, when you clock into work, until you clock out, your employer controls your day for the most part. They control what work you do, they control how you do it, maybe how fast you do it. Of course, they have to abide by certain fair labor practices, but they have to give you certain breaks. But if they want you to have a longer lunch break, they can let you do that. It's basically, though, the point is when you clock in, you're completely controlled for the most part by that employer. And that's really what defines the difference between the relationships of employees versus independent contractors. And so again, a court is not really is virtually not concerned at all about what you've called yourselves, because people can call themselves anything. You could say anything, you get somebody else to agree that you have some certain legal status, but the law is still going to apply the way that it does. So what a court's going to look at if this becomes an issue, just like with partnerships, they're going to look at your actual behavior. So you can sign an agreement with somebody who's doing work for you as an independent contractor, but if you treat them like an employee, in other words, if you boss them around every day, then the court's going to find that you had an employee all along, and you may find yourself in a situation where now in the lawsuit you're actually held vicariously liable for some tort they committed. Maybe they injured somebody. And also potentially for some of these other things we talked about, again, with like employment taxes. So yes, most importantly, there's a few other things that they'll look at, but the most important thing that a court's going to look at, again, is the level of control and whether you're actually really dictating the way that this person does work. And if you are, then that's an employee, again, regardless of what you've said or what you think in your head is the case. This is a slide that just kind of shows you, for convenience, some comparisons between these three different concepts. Okay. Oh, and let me go back just briefly to vicarious liability. What this means is, as the owner of a business or as the employer, if one of your employees, if they are a true employee and that you control what they do day to day, when they're on the job, if they've done something, even if they were the person negligent, and you weren't personally negligent, or you didn't you didn't tell them to act in a way that ended up being negligent, as long as they are acting within the course and scope of their employment, as the employer, you are vicariously liable for things even that they have done wrong personally. So this is another important consequence, again, of defining this relationship. So they may have been negligent. You didn't tell that they drive a truck for you, and you didn't officially tell them to speed or to run a stop sign, of course, but they do. And as long as they're on the clock, basically, you're on the hook for it. Okay, so somebody who's injured by that person, or while they're on the clock, can hold the business vicariously liable. Now, this is true for most everything that happens, I say on the clock. The official language is in the course and scope of employment. And there's a concept that's an exception to this, which is called a frolic and detour. And this is where they may be on the clock, but they have, frolicked and taken a detour while they're still on the clock. So in other words, somebody's driving a truck for you, and they're not actually on their route. They, for whatever reason, before coming back to work, they drive across town to, I don't know, play putt-putt golf or something with their friend, and the injury occurs there. That is likely considered a frolic and detour. It's a detour of, in that case, a literal detour from their route back to work, but it's also a detour from their obligations and responsibilities, and a frolic outside of their job duties. And this happens a lot. People are on the clock, and if they can get away with it, they might go do something else when they're supposed to be staying in the course and scope of their normal employment responsibility. So that is an exception to vicarious liability if the person has deviated Another exception to this, it's kind of the same thing. If when somebody has acted intentionally to injure someone, you may not be liable for that unless it can be shown that you were negligent in hiring this person, which would mean that you'd have to, if we look at duty, breach, proximate cause, our elements of negligence, we'd have to show that they had a duty to try to know or to learn of some proclivity for acting this way, and that they were able to, that it was somewhat foreseeable. So if you hire people to work in a daycare center, again, there's vicarious liability. And, well, let's think of another example. Let's say you hire somebody to work in a grocery store, and this person had a series of violent felonies on their record, and you never did a background check on any of your employees. Well, that's a situation where you could have pretty easily figured out that this person had a tendency to violence. So you may be in a situation there where, under a negligence doctrine, you now may be liable for something that certainly wasn't in the course and scope of the foreseeable employment responsibilities, but you do have to be careful about that, where the situation is such that a little, due diligence could have uncovered this potential such that you may be liable on just a negligence theory. All right, so now we begin by talking about the at-will employment doctrine. A lot of people don't know this, or if they do, they're not quite aware of its severity. What's important to know at the beginning is that this is the general rule. So you always have to start there. When you have whatever the general rule is, your analysis always has to begin there, because everything else is an exception. So you have to first start by saying, this is the general rule, so this is going to apply unless I can find some specific exemption. So the general rule in America is that all employment relationships are at will, in that you can be fired for any reason and you can quit for any reason. In the movies and TV, people always give 2 weeks notice, and that's actually not some requirement. That's just a tradition, and of course not a bad idea in any situation where you're going to bail on somebody to give them notice. But that is not the rule under the law. That's not the general rule. The general rule is that you can say, take this job and shove it, and walk out the door right then and there. But the employer can also do the same to you, essentially. Again, that is the general rule. We're going to discuss particularly some statutory limitations that were passed during the Civil Rights era to protect people from being fired for specific reasons, because the at-will employment doctrine means if you can be fired for any reason, you can even be fired for a ridiculous reason or a bad reason, or what many would consider maybe an unfair reason. But there's some reasons, again, that we'll talk about later, like being fired for your race, that have no basis in any sort of rational reason for firing someone, because they're based on immutable characteristics that have nothing to do with anything. They're just something that you just happen to, some characteristic you happen to have that is not related to the quality of an employee. So again, this is the general rule. You can quit anytime you want, or you can be fired anytime and for even a bad reason, unless we have some exception. So your boss can basically just say, I'm just sick of looking at you. Get out of here. And a lot of people have something like that happen, where to any reasonable person we would say that's unfair, and it's probably not good business practice. That's another reason you don't want to do it. You can get away with it, but no one's going to want to work for you if you just arbitrarily fire people. So that's another sort of practical limitation on it. So before we get into statutory exceptions to this, I want to look at a general exception to this rule, which is an exception to a lot of concepts, where we have a general rule, but if you have a contract with somebody and you guys spell out some other agreement between yourselves, then you can contradict or add to the general provisions of law. And that's true with the employment relationship. If you have an employment contract between the employee and employee, the at-will employment doctrine basically still applies, but it now cannot contradict or contravene the terms of that contract, because you've agreed to something, and whatever those terms might be. Now, most people probably aren't going to have an employment contract. Upper level senior management and people like that, especially the CEO of a company, will have a written agreement that spells out certain things, what they can be fired for, what they can't be fired for, what's the guaranteed salary, for how long are they guaranteed employment. Some people might just have even a very simple one that just says, you're hired to be in this role for the next year, to be renewed if we want to, and you're guaranteed this salary. In that case, basically all that does is it guarantees you a salary for a year, without being fired, just at will. Now, again, most people don't have these like express contracts. So then we go to another type of contract, the implied contract, where there's reason, because of the actions of the employer, to imply some contractual terms between the employee and the employer, based on a theory of implied contract. This usually, it might be based on statements that the employer made to you, but it comes up a lot with policies, the past practices of the employer. Courts expect, generally, you can't set policies for the employees that are there at the time that you're hired and then contradict them, because that's presumably a part of the reason that they're coming to work for you, that they, that they can rely on these policies. So if you see the employer, let's say they have a policy that says you can't be fired without a hearing with this panel or a chance to be heard in this way or that way. If they don't do that, they've now arguably breached their implied contract term with you to follow that procedure. Or if they've always, even if it doesn't say that specifically, but if everybody who's ever been fired has always had a chance to appeal, and now all of a sudden they change their mind with you because they just don't like you, then again, they're going to be in a situation where the employee now has a potential implied contract claim, which again is an exception to the at-will employment doctrine. Employee handbooks also come into play here, and then the evaluations are other statements that are made that an employee generally can rely on. If your last evaluation says he was, completely satisfactory, an excellent employee, and then all of a sudden you get fired, and then within that time period they're saying that wasn't actually the case, they're not going to be able to contradict the thing that they've given you to rely on to understand what the expectations are, again, under this kind of implied, as if this is sort of an implied contract term. So this slide, I talked about this already, vicarious liability, kind of jumped ahead there. Again, though, keep in mind this theory of negligent hiring, that is a situation where the employee acts outside the scope of employment, particularly doing something that's intentionally outside the scope of their employment. You may still have a theory of recovery against the employer. It's going to be important, of course, because the employer is going to have more money and particularly insurance policies to cover their vicarious liability. So negligent hiring is a theory whereby we're saying the employer should have known that this employee was capable of this kind of behavior, and they breached their duty to conduct the due diligence that would have told them not to hire this person, or maybe not to have put them, not to have let them do a certain type of job. So they may have been able to hire them, but maybe you've got a company that does a lot of deliveries, and you do a background check and you find the guy's had a couple of DUIs or is like a serial DUI offender, maybe he can work for you, but it's probably incumbent on you as the employer not to assign him to be behind the wheel. Or, depending on the situation, maybe not to hire him at all, but particularly if you know that the person's had, or just a really bad driving record, even for that, then maybe you can hire him, but maybe not. It's incumbent upon you maybe not to put him behind the wheel, because you have reason to know you could be creating a dangerous situation there. Here's just a case example about a guy, how this comes up, who attacked somebody at Food Line. This is actually a South Carolina case. I'll let you pause it, and you can read that on your own. So that's where we'll end this chapter, and the next chapter will continue our discussion of the at-will employment doctrine, and then look at some more employment issues before ultimately moving on to talking about specific anti-discrimination statutes that apply to the employment relationship.